attacked EACC and NPS officers in lawful exercise of their mandate. Now this has been reported and is captured under annexure number R38. Kitale Police Station. R38. PR38. Annexure PR38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection now is founded on section 106B of the Evidence Act.
That is your name.
Release of your counsel first accused. Section 106.
Based on
Section 106B
on electronic evidence.
for electronic evidence.
You get your time.
And I'm not raising an objection because it's highly important.
You get your time, get it 15.
Possible. We have a next
I want to confuse the direction.
Yes, we have next a series of photographs marked as RR1 to RR37.
1, 2, R,
37. Your Honor, those photographs depict vehicles belonging to ACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing one of the unit.
executing
their lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
come again. Miscellaneous application number
E716
E716
of 2025. That is detailed in paragraph number 4. Now, photographs RR3 to RR10. RR3 to RR10. They depict the motor vehicle KCH 046T.
come again 0
46T. R11 and 12 depict KCP 628X after the violence. Photograph R11 KBU 7.41. And photographs for RR14 to RR26 depict the motor vehicle KCF 541 U. KCF 541 U. Then at paragraph 7 and paragraph 8, the officer depots.
Sorry?
Paragraph 7 and paragraph 8, Mr. Ronald depots that after vandalizing these motor vehicles, important documents were taken. Now, you take judicial notice of the position of the first case. The witnesses in this case, Your Honor, upon disclosure, are his subordinates. People employed under his government. Now, what is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that is maintained with the witnesses.
The test is?
A reasonable prospect that the accused person will tamper with the witnesses and the evidence.
Perhaps, I'm aware of the directions you have given about the temper. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit to that effect that the proposed witnesses are subordinates of the government.
Give a guidance again. Whatever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one suit.
I won't get it.
But let me record you first. Mr. Kula, give me some time. This record is objection. Everyone have a minute to
I will
continue.
repeat your order.
How long more? I thought we were going to take 3 minutes. Now we are going, will we sit here the whole day? Just off the cuff. How long more?
I'll tell you, it's clear with you. Just summarize it.
10 minutes. Continue, Mr. Fu.
Listen, I will repeat
So
that
your 10 minutes.
we are submitting that once disclosure is done, the witnesses will be calling officers from the first of this time. Those are disciplined. I'll get the second link. It's a very good offense.
Sorry?
I got the second compelling reason.
Second.
When appraisal of the child sheet, the amounts will appear casual.
The amounts will appear.
Minimum, 1 million. I should believe Your Honor will win this case, and will draw your attention to section 62, 1 of the same. To one or second. In the event we succeed, that provision is very punitive.
In the event,
We succeed,
we is
the
the
DPP
DPP
prosecutes this case, we get conviction.
is successful.
Yes, we will be moving to section 62, subsection 1. I learned that the severity of corruption cases. Will it be a recipe for someone to interfere? We submit to the positive, Your Honor. Lastly, public safety. I've alluded, Your Honor, to what transpired yesterday. And I've alluded that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will happen. And we are apprehensive that in the interest of justice, in order to protect the integrity of the criminal justice processes, that our application is allowed, and at least for the court to have an independent opinion, a plea bail report be available. A plea bail report be available before this court can decide on this issue. That should be available.
Mr.
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence. Thank you.
Mr. Chairman, in July, how many of you went to legal school?
I'll take the first one.
Because I listed how many. 11.
Yes.
And one.
Not all of us,
So how many? Just to manage our expectations.
About five for activity.
Right.
We go from drama. You know, drama is just going to be because the issues are straightforward. You know. Okay, let me start by introducing Senior Counsel John Winwa. He's
Good morning.
so we have an introduction. Then I will do this also here.
That is. Oh.
Let me be the first one to draft
I don't
answer.
need to record.
Let me on the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point will be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And sometimes, Your Honor, as a counsel who has now practiced for 33 years, I get concerned
For
when
how long is that?
33 years.
That is not for intimidation.
It's
The right not.
When we
But I'm sure Dr. Hamino is smiling at you.
Actually, it's a sign.
Very sad.
Your Honor, when prosecution purports to teach this court the law, citing authority, citing sections, trying to tell you how to deny it. Before I stand here and talk about it, I'm certain they do not believe in what they're saying.
Sorry, Your Honor. I know the court warned us of decorum, but we plead, I am just 12 years in practice. We plead that Senior Macharia doesn't get personal. We are just here for our cases. Anything that we do is not personal. So we plead with him to have mercy on us and just stick to his case without attacking us. Thank you.
Let us have mercy of the first
Mr. General, to record his objection. There is a special reason, Mr. Njero, I did what I did to your side, so that we remain focused. So remain in that trajectory.
Absolutely. My plea is that we have mercy on the accused person. Let's not talk about mercy on the prosecution or media. We are outside. It is him who's left in custody.
Now, Your Honor, I'll say this with tremendous respect. What we have here is warfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today. And none of us can afford to shut our eyes from that. Independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective, which is to harass political opponents. It is sad, extremely sad. Your Honor, I'll make a confession to you. I was last in a criminal court defending somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to the criminal court to defend someone. Not because of his status, because we can't allow a country to degenerate to a situation where the criminal justice system now be used to harass opponents. That's wrong. And we shouldn't allow it. Your Honor, intimidate. I am one of the few lawyers who have had the advantage of having been part of independent agencies and also been in private practice. One of the few. And I know how things operate in those agencies. I was the first chair of Independent Police Oversight Authority, and we had a lot of run-ins in the executive. Constant interference attempts to direct us on how to do our work, including by the current president when he was deputy president. And this is factual. It's in public domain, it is known.
Mr. Njeru,
I'll give the context. I'll give the context.
the focus.
Yes, I'll give the
The
context.
focus here, Mr. Njeru, a minute.
I'll give the context.
A minute, Mr. Njeru. The focus here is the accused, the law, the constitution. You understand our parameters, if you like. There are some parameters I am unable to swim in. I may not be very able to swim in. But I can swim in the constitution, I can swim in the law, I can swim. That's why I can swim in submissions around those lines.
The reason why I'm telling you that, Your Honor, so that I can go straight to the context,
Yes.
is that independent agencies will come here and pretend more often than not that they're doing their work independently. I'm telling you, as somebody who has been in those agencies, that unless as an individual you have the wherewithal to resist and do your work correctly, very few manage to do that. That's the context. I'm not here to talk about where I was.
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matrix that the very learned senior is giving us are things that, with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, But for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner. We understand. But let him get back to our case. Thank you.
To respond to that, look at the affidavit.
A minute, Mr. Chair. I complete recording.
You're gonna,
Mr. Njeru, your brief response, you are responding?
yes. If you look even at the affidavit, they've made general averments. To start with, problem number one, they serve us in an affidavit this morning. What time did they expect us to respond to that affidavit? You know what is the truth? That it is designed in a manner that will expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, the accused person continues languishing in custody. You know those tweets? Then the affidavit itself is marred with general averments. This is factual. They are talking about respondents agents. They are not naming which agents.
So just to be clear, you responding to the objection or you continue with your submission?
I'm responding to
That I'm
something
clear.
here. He cannot say that I'm making general averments, yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he expects that I shouldn't be able to respond to that. At least from the back, in the very least, that should be expected. He can't have a steak and eat it. In fact, we should be given more latitude because the subject of these proceedings is the accused person. The rest of us are sleeping here, and then we walk away. But there's the subject. That is the person we should focus on.
Guru, give me time to give direction. Somebody wish to guide again, focus on your government on the day. That is the issue of the table. Continue, Mr. Njeru.
Much obliged. Now, Your Honor, the accused person is somebody who has served this country for a long time, not just as a governor. Knowledge of who he is in the public domain, including very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. besides being a governor, elected governor of a county. What was so difficult was just someone to court, telling me to appear in court in such and such a thing. Why all the drama? Arresting the man and putting him in custody for this kind of charge. Why? It can only be for the sole purpose of punishing him. It can't be anything else. And it is that desire to continue punishing him that is driving the application for him to be denied bail. You cannot allow yourself in realizing that objective. You can't. I have consistently seen the last line of defense for this country. The only one remaining, Your Honor, is the judiciary. And if judges and judicial officers allow rights of accused persons to be taken away, we have no country. None whatsoever. And let's not think that when you allow that trajectory, that anyone will be safe, including the prosecution itself. No one, I can tell you, Your Honor. We need to learn from history. So regardless of what happens here with these protracted submissions and responses and comments, Your Honor, I beg, do not fall under the trap of saying that you're going to write a ruling another day to be meted in release in custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court, and he never appeared. One of my colleagues here will speak about the facts, then the chaser, but I can tell you, Your Honor, this alleged misconduct that is being talked about, the accused was in Nairobi. Whatever is alleged to have happened was in Italy. How do you start connecting him to something that is happening hundreds of miles away when he was in the office of EACC? How? So I'll allow my colleagues to say something, but I'll end by saying this. The reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Lawful use of the criminal justice system to intimidate and harass opponents. Your Honor, I once again plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Thank you, Your Honor. Briefly, just give the last aspect.
You can continue, Mr. Jiru.
Your Honor, just to associate myself with the submissions made by Malani Senior, and to draw your attention to the content of the charge sheet, from where you will be able to drive the mischief. And the accused person is currently...
Slower. Pause after every sentence. accused person.
It's not surprising that the accused person is charged before you with another person, Wafula Masungo, who is not before you. This is not by coincidence. It is not that Wafula's whereabouts is not known. It's because, Your Honor, the state was in a hurry to perpetrate this mischief. In normal circumstances, Your Honor, such proceedings would not have commenced. When you sought for explanation, Your Honor, Manadi Senior indicated that he was seeking summons. It's the same mischief, Your Honor. When you sought for clarification from the prosecution, the opposition, Your Honor, was that you seek summons. And the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for you to deny appeal must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODPP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies. Also, the elections, the directed the focus on the charge sheet. If council has any, also the elections,
Minute and recording is done.
the direction,
Minute, I'll give you the directions. Mr. Akula, you can continue.
the directed the focus on the charge sheet and the issues related to bail. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him to take the stand on the other side and we will be willing to use. So let me speak on bail. The rest of this person. We just want to give any motive to anybody unless they are willing to take the law.
Your response, Mr. Njiru.
Your Honor, my response is contained in the affidavit filed by the ODPP. But it's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I also proceed in response to the substantive application,
Minute. You must give direction in the objection. I remind that once more, I think be loyal to the law and bond and bail. Avoid instances which may persuade me to request the fact, evidence from your end,
I am well
which
with you.
will render you in a very awkward position.
I am well with you.
But
Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
after every sentence, it tells.
And there is no affirmation in the affidavit